Welcome to SCOTUScast, Test for Enhanced Infringement Damages Edition. Thank you for tuning in. On February 23, 2016, the Supreme Court heard oral argument in Halo Electronics v. Pulse Electronics, which was consolidated with Stryker Corp v. Zimmer. Both of these cases involved claims of patent infringement relating to the sale of marketing of various inventions. Both also involved a determination by the U.S. Court of Appeals for the Federal Circuit that an award of enhanced damages for infringement under 35 U.S.C. 284 was not appropriate, after applying the circuit's two-part objective-subjective test for willful or bad faith infringement set forth in re Seagate Tech, LLC. The question before the Supreme Court is whether the Federal Circuit's refusal to allow enhanced damages absent a finding of willfulness under its two-part test contravenes the plain meaning of 35 U.S.C. 284, given the Supreme Court's recent rejection of an analogous framework imposed on 35 U.S.C. 285, the statute providing for attorneys' fee awards in exceptional cases. To discuss the case, we have Gregory Dolin, who is Associate Professor of Law and Co-Director, Center for Medicine and Law at University of Baltimore School of Law. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Professor Dolin.
Both cases have to do with the standard for awarding enhanced damages in patent infringement lawsuits. What generally happens in a patent infringement lawsuit is if the patentee, in other words, the patent holder, wins the case, the infringer who lost the case needs to pay the patentee some sort of compensation. There are different ways of measuring it, depending on what exactly the patentee has proven, but usually some sort of money exchange takes hands. And the amount of money that is exchanged is usually determined by a jury that has heard the evidence about the patent's value, about the level of infringement, and other related matters. One of the sections of the Patent Act that is codified in Title 35 of the United States Code allows the court to award enhanced damages, in other words, up to triple the amount of actual damages to the patentee. And the question presented to the Supreme Court in this case is, what exactly is the standard for awarding those enhanced damages? In other words, when is it appropriate for a district court to invoke the provision allowing for doubling or tripling or any other sort of increase of the damages otherwise awarded by the jury? The Federal Circuit, the appellate court that deals with most patent cases that come up, has come up with a test in a case called in re Seagate that essentially states that enhanced damages are inappropriate if, during the course of litigation, the accused infringer managed to present an objectively reasonable defense, even though the defense ultimately was proven to be unsuccessful because, after all, the infringer has now lost the case and been ordered to pay some sort of damages. If the defense was objectively reasonable, not frivolous, that means, under the Federal Circuit law, that enhanced damages are inappropriate. Actual damages are fine, but enhanced ones are not. The problem with that standard, as argued by the petitioners in the case, is that it ignores what happened during the actual infringement. It only looks at what happened after arising litigation. So, in other words, a hypothetical that comes up, and actually not so hypothetical, what was argued in these very cases, is that before litigation started, the accused infringers actually went ahead and explicitly copied a patented product, and only after the case was brought to trial did their well-paid and good lawyers found potential problems with the patent. Problems that ultimately proved not to be a problem because, again, the court found the patent to be valid and infringed. And so the question really that the Supreme Court was facing is whether or not we should focus on the actions of the accused infringer during the time of actual infringement, or whether we should focus on that time as well as actions during litigation. And that matters significantly because in almost all cases, as almost all justices are recognized in the back and forth between both counsels as well as the attorney for the United States appearing as an amicus supporting the petitioners, in almost all cases, a a company, especially a large enough company, the one that has money, can find an attorney who can then go out and find some sort of art, some sort of documents that would put a patent in question, even though the question is ultimately favorably resolved in favor of patentee. And that is how, in this very case, the respondent got out of paying enhanced damages. It is always a fool's errand to predict how the courts will rule, but if two major themes have emerged, is one was articulated by Justice Breyer. Theme was more pro-respondent, in other words, against enhanced damages being freely available or more freely available. And his theme is that sometimes there's a number of patents out there that are not necessarily clear as to what they mean, what their boundaries are, and therefore, are they really infringed or are they really valid? And his suggestion was that if we threaten, essentially, we put the sword of Damocles over accused infringers, even though the patents themselves are fairly weak, that might retard innovation. That might create significant barriers for entry to the public, to the non-patent holders, to the competitors. The other strain of thought, kind of on the other side, was this idea that precisely because you can almost always find potentially invalidating prior art that ultimately turns out to be not successful, is that it would essentially mean that almost never would there be, except in very, very few, very egregious cases, almost never would there be enhanced damages. And at least some justices, specifically, for example, Justice Sotomayor, recognized that that was not really the historical practice. Historically, if you go back before 1952, if you go back to the 19th century, almost always was the infringer not just required to pay for the actual act of infringement, but actually was punished for doing so, because it was viewed that infringer is really taking somebody else's property, essentially stealing or trespassing, however you want to analogize it. And so historically, enhanced damages were available or almost as a matter of course. And so there was some recognition that perhaps the Federal Circuit's test has strayed too far from both historical practice and, as Justice Roberts pointed out, from the actual language of the statute, which is actually pretty terse. It simply says that the courts, district courts, have an authority, have an ability to enhance damages in a patent infringement case. It doesn't actually set a standard. And so that is kind of the debate that was going back and forth between the patentees, who were the petitioners in this case, supported by the government, and against the respondents, as well as on the bench. From the transcript that I've studied, it seems that more questions were asked of the respondent, which occasionally indicates by some studies that they're less likely to win, but again, I would think it's a fool's errand to predict who will win and who will lose. I think it's better to focus right now on what were sort of the major concerns raised, and I suspect that when the Supreme Court does come up with this decision, it will try to craft it in such a way as to make sure that not every infringer is potentially liable for triple damages or enhanced damages, but that fairly strict Federal Circuit case law is also probably somewhat relaxed, simply because that has been the history of over the last 5 or 6 or 10 years or so, where the Supreme Court has taken a number of Federal Circuit cases, looked at them, and said that Federal Circuit has really set up overly stringent guidelines, and that really the law should be somewhat more fluid and somewhat more in tune with the record developed at trial, and somewhat more up to the discretion of the trial judges. So that's how I think it will go. Whether or not petitioners will win their entire position and their entire argument, I'm not sure. I think, again, Justice Breyer was particularly skeptical of it. At the same time, it does seem that the Federal Circuit standard not elicit much support on the bench, perhaps except for Justice Breyer. So I suppose we're going to wait and see, but it is an interesting issue that's going to develop as to when is the relevant time frame as to which to look at potentially egregious activity. Do we look at simply at the time of infringement or the time of litigation? And hopefully within the next couple of months, the Supreme Court will give us an answer.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.federalistsociety.org/multimedia.